before I introduce our illustrious speaker, I wanted to advise him and others in the class that today we are hearing from Anita Zipfel and Tia Stewart on not Rule 506B, traditional private placements, but on what I call noisy public-private placements under 506C of Regulation D. Not many of the colleagues I talk to regularly ever use it, but I have recently talked to some colleagues in D.C. and New York who have on occasion used it in rather unique circumstances. But first, we're going to hear from one of my favorite former students, Carlos Hernandez Ocampo. He is a U.S. Navy veteran, originally from Cuba. But he came here with his father. His family later joined, and he went off to the Navy. Then he came to law school here at U of L at Brandeis School of Law. He excelled in trial practice and actually distinguished himself with the MBA entrepreneur track students at the Entrepreneurship Clinic here. Before that, he received his bachelor's, and of all things, I think it blends, but most people probably don't, in studio art. And he was at the Haidt Art Institute with a concentration on painting. And they had the student exhibition this past week, and I went. And just out of the blue, I got the invitation here at U of L. I thought, well, it was fun to participate at student events. So I went over there, and it was really, it's a beautiful facility. And I didn't know they had glass, blowing and everything else going on over there. It was very impressive.
You went downtown to the Crescent Center?
Yeah,
on Main Street?
Yeah, on Main Street.
Oh yeah, that's beautiful.
And isn't that where it is, the Haidt Art Institute? They were doing the student exhibition, and it turned out the friend I was with actually knew a couple of the students who were involved in sculpture. Anyway, so as I said, he's a native Spanish speaker, born in Cuba. Great story there. He's devoted his life to making meaningful connections with the people he meets. His passion for communications led him to learn several languages. He now speaks English, Spanish, Bosnian, I have to explain that choice over here one night, and Italian. But art remains in his blood, from applying creative artistic concepts to complex legal issues, to innovating new ways to deal with traditional compensation and other corporate problems. His passions are essentially art, business, and veterans in everything he undertakes. So why have I invited him? Well, one, he was one of my students, one of my better students. He showed an enormous energy for the law. He also shows enormous energy in the field of entrepreneurial endeavor. Over the past 2 years, I have personally seen him engage with Gil Holland, who's the entrepreneur redoing the Portland area, and originally sort of got the ball going on Nulu. He's met with Tom Cottingham on numerous occasions, who will be one of our speakers. And he really is a champion of that old saying I got from my grandfather, which is, and the one that you have heard from Woody Allen, what's the secret of your success? It's always showing up. Just show up. Be there. If you don't show up, you get nothing. So there are probably 25 meetings a year I absolutely do not feel like attending. And you show up almost every time, you're glad you did. You ran into somebody you knew, or you heard about an opportunity, you heard about some wrinkle in the law you didn't know existed. So he's the champion of that. So with that, he's pretty new out there, but he's already making a mark. So I thought that you guys would. Actually, Tom Cottingham has come and suggested, why don't you invite Carlos? I said, all right, I'll see if he's willing to do that. And of course he was. So Carlos, I'll turn it over to you.
Thank you.
And you can sit here, you move the leg.
That sounds like a very impressive person,
so I don't know if I'll be able to fill his shoes, but he just read my bio from the website.
So, like Manin said, I'm Carlos. Hi. I was sitting there where he was sitting right now just 2 years ago. And to give you a little bit of in between the lines, I got out of the military in 2014, started actually I was still in. I didn't get her until March, and I started my art degree classes in January 6th. You figure that timeline out. But so I got it right, went into it. I actually had to take leave. That's how I got the timeline. I didn't take any vacations for like 2 years. Saved it all up so I could have 3 months worth of vacation to go to school. That's what I did on vacation. And you know, I got my art degree that same exact summer. I graduated in May. In August, I started at the law school. This was the only law school I applied. So it was here or I'll be making art downtown. And yeah, you know, did law school, took every class that Manning offered, pretty much. And upon graduation, I realized that I wanted to be, you know, I was always very entrepreneurial. While I was in law school, I started my own photography business, and it went very good. I actually had to shut it down because I had way too many customers, and it was taken away from my time in school. And the last year, I was able to just transfer it all to my brother-in-law, and he's now a photographer with his own business, and all my clients. And you know, so yeah, I graduated, and I had to wait a whole year for the bar because take the MPRE seriously. I thought it's an ethics test. I can just show up, put my name on it, and I'll pass it. That was not true. So I bombed the MPRE, and it's a requirement to sit for the bar, as you guys will learn. And so yeah, take it seriously. Studies just 1 week, literally. I did it, and I had really high scores when I actually sat down and opened the book on it. And I was able to sit for the bar, pass it the first time. But because I've always been kind of, like Manning said, energetic and proactive. I couldn't be a lawyer until I passed the bar, so when I graduated law school, I took the knowledge that I took from a law school setting, working with the entrepreneurial clinic and just my own entrepreneurial vision, and I did business consulting for a whole year, from May 2018 until May 2019 when I was sworn in. I was sworn in at 10 in the morning on May of 2019, and I saw my first client at 3 o'clock in the afternoon on May 1st of 2019, same day that I was sworn in. And I was in court for motion hour the Monday after. That was on a Wednesday, which was like May 5th of 2019. And all my older lawyer friends said, "What the hell are you doing? Why are you in motion hour 4 days after you got sworn in?" And I'm like, gotta pay the bills, you know? So I'm a trial by fire type of person. If I don't know how to do it, I'll figure out how to do it in the last 24 hours. So any questions so far before I start going? Yes?
Why did you want to get out of business consulting so quickly? Was it just kind of an interim job, or? It
was just, well, I opened my own business consulting firm. So it was just a way to use my knowledge, you know, in the legal field and business field as a consultant until I got my license to practice law. So, and I was able to transfer like 3 or 4 of my business consulting clients into my law practice once I could practice law. So
you continue to consult with them about both business and legal matters.
Yeah, and I actually, January's been crazy for me because I probably signed up more clients than I did in the whole last year alone since May. And I signed like 15 new clients, and 8 of those are straight business consulting clients that just need a little bit of legal work to do.
So you really didn't stop your business consulting business, you just converged it?
I just started doing that out of the law firm.
Right.
So it was 2 separate entities.
Right.
So
and one of the reasons Carlos is here is about to help you develop the understanding that your own law business is an entrepreneurial endeavor.
It is.
I think he has a lot of insights on this.
It is, and so it's funny because, like Manning said, I'm very fresh out there, but I'm already the chair of the Solo and Small Practice Division, the Louisville Bar Association.
That was pretty amazing.
I thought it was too, especially since they asked me to do that since November of last year. So officially, I had only been practicing law for 6 months.
Say the name of the committee again.
Solo and Small Practice Section. Yeah, so I'm telling older lawyers how to run their law firms, which is kind of a gag, but you know. You'll
It's
be
actually one of the stronger services the Louisville Bar Association offers. I think they've done CLE and other things in this area.
Yeah, but they have been defunct for like 2 years. The last
Okay.
person that did anything with it had retired and was gone for 2 years. And it was actually, I'm co-chair with Dean Hajic from here, the career dean.
With Laurel.
Yeah, and she's the one that recommended me for it, and she said I can co-share, with you if you want the
Sure.
extra boost. Since you're so new, you don't feel like you're out there by yourself. So I said, absolutely. I will even be vice chair if that's, what it takes to get my name out there. But like Manning said, I'm pretty entrepreneurial, and who here wants to open their own law firm? Don't. I'm kidding. Do it. You'll regret it, but do it. It'll be fun. But so it's true. There's a huge difference from, I'm a lawyer, so I just practice law, to I own my own law firm. All right. So the first thing is you have to be entrepreneurial, and you have to see it as a business owner yourself. Practicing law is just what you do while you're at your business. So if you had a bakery, yeah, you bake cakes there, but you actually own and run a business. And a lot of people have a hard time, including lawyers, differentiating the two of them, okay? And I had an older attorney get mad at me because I told him at the Louisville Bar Association, a roundtable discussion, I said, look, we're just plumbers, all right? People call you, you do a job, they pay you, and every now and then you get your hands full of shit. So that's, he didn't like that too much. I said, but you're no different from a plumber. If a plumber runs his own business and you're a lawyer, you run your own business, it's just lending a service to the people out
Except the plumber makes more money.
there. Yeah, plumber does make much more money. I've been thinking of getting a plumbing license here in Kentucky. But being entrepreneurial doesn't just help with your business. Specifically for the area, where would you like to open your own law firm? I mean, the three that wanted to. What type of law do you want to practice?
Probably like corporate law, business law, or employment law.
Yeah.
I'm not certain yet, but I'm thinking securities.
Same as her, but probably not the employment law part.
Okay. Well, I do all of those and family.
Okay.
At first, and Manning himself was the one that recommended that, is take any client that comes in with a check that doesn't bounce through the door, okay? And after I had the second divorce client crying in my office, I realized I can't do divorces anymore. So I had a friend that does family law, and he's got a heart of stone, and he said, yeah, sure, transfer them all to me. And but you'll find out very, very quickly what you want and don't want to do, believe it or not. And that's sound business advice. Take anybody willing to pay that comes in through the door so you can pay the bills. But there's just some things that your character's not attuned for. A lot of people think that I will be an awesome litigator because I like talking and I don't have confidence issues and I can stand in front of a judge. I think I'm a horrible litigator because that's only 5% of what a litigator does. The rest of the 95% is keeping up with the current law, filing motions like 10 times a week to defend the motions that your counterpart filed while you were sleeping. Show up to almost motion hour every single Monday here in Louisville. You have to have all of these deadlines plotted. You have to make sure that you have statute of limitations for all of your cases in your head. So there is so much that goes into being a litigator that I couldn't do it. I had a few litigation cases, and again, quickly, I suck with deadlines. I was running late this morning on my way in a little bit. So that's your nature, your personality, that will guide what type of law you do. And if you find yourself doing something like employment law and you love it, and doing something like securities and you hate it, maybe switch. Go ahead and do something else.
Coach, let me add something to your statement about employment law, because I didn't know you had that interest. So I had lunch with another alum of this law school. Yeah, for sure. Maybe a year ago. I don't know. You know Gary Adams?
Yeah.
All right, great guy, full of energy. Well, Gary Adams, when he finished, he didn't know quite how to build a practice. But what he noticed was the big firm. He went to these CLEs and met lawyers, and basically met lawyers with some of these big defense firms. And what he told them was, well, when you know of employees, because you only represent the firm, so you always have a conflict. If employees should come to you guys, would you consider me as a reference? So now he's hired like 8 lawyers. He's got so much work to do simply because he's getting those referrals, and nobody else was in that niche that had the relationship with the big firms to get the referrals. So it's been a really lucrative area. And it's not just appearing and hearing, it's just giving general advice as well. So it's unbelievable how you may find a niche in the end where somebody's just not doing it.
I know, I did.
Yeah.
So yeah, you know, going off of that, it's funny because I read the book last night that you assigned them for class.
Yes, good.
So if you haven't read it, you can read it in like 5 hours if you have insomnia. So it's pretty good, and I kind of agree with a lot of the things that Peter Thiel talks about that book, because like he says, it happened to Gary Anderson, it happened to me, and it's find a place. Don't try to copy what everybody else does. Don't try to, it worked for this guy, it worked for that guy. Don't try to follow that track, because you may end up getting a little bit of success at first, but then you're gonna taper out. With me, I wanted to focus on early stage startup companies. I love entrepreneurs. I'm an entrepreneur myself. I love that crazy positive energy that, you know, I feed off of it. I have big dreams. I want to create the next, whatever, Google, you know. And when I was graduating, I talked to Manning, and my other mentor here is Will Metcalf. He runs the Entrepreneurship Clinic.
I'm meeting with him tomorrow.
I know, he texted me, he said, I'm finally meeting with Manning.
Right.
Anybody here in the Entrepreneurship Clinic? Oh, okay. I talked to you earlier, didn't I? Yeah. All right. So yeah, you know, him and Manning were my 2 mentors because of the type of law that I'm doing, and I met with both of them, and it's funny because I told you I want to deal with entrepreneurs, artists, immigrants, and veterans. That's it. And both Manning and Will said, well, they don't have any money. So how are you going to get them to pay your fees, because you're running a business? So that was my challenge. My first barrier to entry, I guess if you will, business challenge is how do I talk to the people that I want to help and still make my services available to them in a way that they can pay. So I started doing a lot of research, and I found out a lot of lawyers in LA, Florida, New York, they're doing flat fees for business clients. And they're doing flat fee project-based, which is kind of what a lot of consultants did too, so I already knew that type of model. And instead of having long hourly fees, they also do subscriptions, memberships, so just very flexible fee arrangements for your business clients, because they're trying to ram up funding and things like that. And I found out what were good prices for Louisville, Kentucky that wouldn't, put me out of my shirt, but still be affordable for my potential clients. And I started going to everywhere that they were. A lot of lawyers, they say, hey, in the same roundtable, like 5 lawyers asked me, well, where do I get clients? Because there were newer lawyers in law firms. And I said, well, what are you doing? And they said, oh, I'm talking to other lawyers. I go to LBA meetings. I go to KBA meetings. I go to KJA meetings, which I didn't know what it was until they explained to me. Kentucky Justice Association, you heard of them?
Yeah.
Yeah, for plaintiffs and things like that. And I said, well, are you representing lawyers? And, they're like, no, what do you mean? I said, well, referrals are nice, but unless you're representing a bunch of lawyers, you're only hanging out with lawyers. I wanted to represent entrepreneurs, so I go to all the venture connectors luncheons, which is once a month. And that's where a lot of the entrepreneurs, the investors, and business stakeholders here in Louisville attend to. On Eventbrite, you can just put entrepreneurship Louisville, Kentucky, and you'll find 1,000 different classes, seminars, things.
That's on which site?
Eventbrite. Yeah, so it's you can download the app too.
I think I have it.
Yeah, and it'll tell you all the events, and there's classes and there's seminars. Most of them are free. They had something that was they have creative mornings, and they have like Tuesday coffees or something like that, which are not Story Louisville. And I just went to every single event where my potential clients would be and said, hey, I'm a lawyer, you need help? Because that's what I'm here for. And the more that you show up, like Manning said, the more that you're around, the more that you're available, people start talking to you. And at first, it's a lot of free legal advice. It's, yeah, you know, maybe you should do this or you shouldn't do that. But when they get the funding, the capitalization, and they realize that they're getting a bunch of agreements thrown their way from investors or you know, even accelerators that give them free legal advice through area attorneys and things like that, they're like, well, maybe I need my own lawyer to take a look at these things because I don't want to be signing my life away. So a bunch of them started calling. And that transfers to anything and everything. You know, my friend that's a family law attorney, he said, well, how do I do that for family law? I said, well, go to the women's shelter, you know, talk to churches that have refugees for, you know, orphans, or have refuge for battered women, battered spouses. Go to different places where people with families would go. And, you know, you do divorces, adoptions, you can go there and talk to them. You can offer free seminars, which I did at the beginning too. I would talk to a lot of the local groups that sponsor and foster entrepreneurs, and I would say, hey, you know, do people have questions or doubt? They say, yeah, they don't know what the hell an operating agreement is. And I was like, oh, I know what an operating agreement is. Let me go and show them for 30 minutes. So I would do things like this, but with where all my clients would be. You know, even insurance carriers, Northwestern Mutual, which Manning got me hooked up with somebody in there, and you know, they had me come in and talk to some other people. So it's how you build relationships, in essence. You know, and if you want to focus on a specific niche, a specific target group, you have to go to where they are. You can't just sit around, you know, hang a shingle and say, oh, you know, if you build it, they will come. They don't know you exist. Unless you go out and you let them know. So, any questions? I like to be really engaged with the audience. As you can tell, I'm having a hard time just sitting here, but I love answering questions.
With the, you mentioned the flat fee consultant or basis for fees. Did that change when you got your JD? Did you raise the price, or did the business consulting fee stay the same?
Well, for business consulting, yeah, it's the same. I actually added some more things that people wanted me to do that I learned, that I taught myself how to do. And, but they stayed the same. For my legal practice, we have ethics and rules that we have to comply with the bar associations. So I established fees that were below a lot of people in town, and that were more accessible for entrepreneurs. And with that, so on fees specifically, it's just good generally. You need to always, when you're setting your own, be aware of the amount of work that you're going to be doing. So I would not recommend to anybody to just say, I'm gonna charge $20 to do X or Y. Do X or Y first. If it's just an agreement that you can draft it. Even if you have client X and client B, for example. I had a lawyer that wanted to work with me, and I asked them to do an independent contractor agreement, and it sucked. And I gave them all the resources, and I said, just client X and client B. This is the hypo, like a professor would. Just give me an independent contractor agreement. And they couldn't figure it out. So, in that scenario, don't go to a client and say, oh yeah, I can do an independent contractor agreement for $50, I promise you'll be great. And then they pay you, and then you have no idea what you're doing. Or it's wrong, or it's not relevant to the jurisdiction that you practice in. So I'm a nerd, and I learned like drinking water through a fire hose. I just read one book last night, but when I decided what my services were, I have a basic set of services that I know for sure I can perform and deliver, and those are on the project-based flat fee model. But I talked to a lot of my clients, and a lot of them have needs that go way outside what a regular LLC or a corporation would be, or something to that matter. And so I try to figure something with them. Last week, I actually asked somebody that told me it was expensive. I said, well, what can you pay? And he said this much, and I said, all right, tell you what, I'll take it, but if when you do this other transaction, you think of me. And they thought of me, and now I'm representing their whole company. So it was one of those that you are flexible with somebody at the beginning, but you understand that they could potentially bring you a benefit instead of just, sitting on a high pedestal and saying, I'm a lawyer, you gotta pay me $1,000 to talk to me,
So are you setting up like when you do memberships or the services that you're providing, is that sort of like a retainer or
Yeah,
something
so
along those lines?
similar to that, yeah. Think of, you took professional responsibility.
Mm-hmm.
So there's two types of retainers. There's a retainer that goes into your trust account and you bill against it. Now, a lot of defense lawyers use that. And then there's the old-fashioned retainer, which is usually a little bit higher, but it's because of the opportunity cost. So when you do business, which is what you want to do too, you have a lot of that opportunity cost, because if you're representing a company, you can represent, a competitor or the employees of that company if they're gonna be at an arm's length relationship with the company.
You can make those non-refundable, can't you?
Oh yeah, those are non-refundable. They can go talk to the Kentucky Bar Association if they want a refund. So, which is always a good idea if you open your own law firm, to talk to them and get advice. And if you don't know something, ask.
It's free and they're very helpful.
Your professors are researchers. I've bothered Manning for things that he didn't even know the answers to, and he said, don't ask me, I have no clue what this is.
I don't know.
Yes. So, but ask. I asked him a question recently, and he told me that he didn't know. Tom Rutledge answer, and I was right, and it was invented. I pulled it out of my hat, and he said, that's what you would do.
Good instinct.
Yeah, that was a good instinct. Just make sure that you're good with so-and-so regulation.
I thought you were right, but I didn't want to be the one to tell you.
I know. You haven't done them before, so.
But it's funny about the flat fee thing. So I guess one of the first, I'd been with it. So the larger firm, I was like you said, the lawyer who is literally doing the plumbing. And I was getting kind of bored after 3 years, and I had an opportunity to join these two other guys who were both really smart. And that's when law became fun, when I became an owner, and I'm actually one of the guys running it and deciding which clients I want, which clients I don't. You'll get that luxury after a while. The flat fee billing thing was a hard thing to grasp, but I had my senior partner, the Tommy Ritchie I refer to sometimes. I'm sitting in a meeting, we're closing some acquisition, and at the end of the meeting they paid, I don't know, $15 million or whatever it was, and the guy says, well, Tommy, what about your fee? Now that we're all done, this has been great, what's your fee? And Tommy, without blinking, I thought about it, I think $100,000 would be fair. No smile, I think $100,000 would be fair. And the client literally just backed up, and I'm like the young lawyer in the room, backs up again, really? And Tommy just as calm says, well, you remember, we did 3 or 4 other deals along the way that didn't close, and I never sent you a bill for that work, so maybe this is a good time to, and the guy smiles and says, it's fair, we'll write you a check.
Well, I haven't found people like that yet.
But that's the flat fee, that was his idea, the flat fee billing, because he wasn't gonna rip them off, because these are among his, quote, I think we've talked about, one of his 20 lifetime clients.
Mm-hmm.
I mean, he'd been with that guy at least 15 years or maybe longer.
And that is, I have like 4 that are like that are lifetime clients that'll be with them until I die or they get bored of me.
Right.
And that's also
because they trust you. Once they build the trust, it's
Yeah.
hard for them to trust somebody else.
It's big on relationships, and with those clients I actually got them at the very, very beginning when I didn't know what I was doing. But the reason they trust me so much was because I would tell them, like Manny said, when I didn't know something. They would ask me something very complicated, and I would tell them, look, I don't know how to do that. You can go and talk to so-and-so, or if you want to give me the chance to learn it, I can learn it because it'll be kind of fun to do it. And then you're involved in some crazy tri-way merger, which was what I was talking to you about, and you have no clue what you're doing because it's different states. So you start calling for help. And you tell your client, if you give them, be honest the whole time. Because most people get upset at doctors and lawyers and go for the malpractice, to the KVA or whatever, to file an action against you because you weren't honest to them. So if you tell them
you knew all about it. Yeah, I
Yeah.
can handle this.
yeah, don't ever overpromise and underdeliver. At the beginning, you might do a little bit of that. It's just good salesmanship. But make sure that you're overpromising within your comfort zone. create a comfort zone that you're like, all right, I know how to do 5 things. There are 7 related things to those 5 things. I'm familiar with them. I don't know how to do them because I've never done one, but I'm familiar enough to where I can put it in my sales
And
pitch or
T, I
whatnot.
think that's what you're doing with the idea we're talking about doing securities work for
Right.
startups among a number of rural counties, for
Yeah.
example.
That is a great idea, and a lot of the entrepreneurship ecosystem in Louisville, Kentucky, is starting to move up to the boundaries of Kentucky because they're realizing fast that it's an untapped market of a lot of entrepreneurs, inventors, engineers, and even investors, people with a lot of wealth in these outlying counties and areas that
But
are
if
not.
you're from there doing it, she's gonna have the edge.
Oh yeah, absolutely.
As opposed to the big city law firm trying to go out there and get clients to trust them.
Absolutely, and
There's a general distrust of Louisville and the rest of the state, I've discovered.
yeah, and I have a friend in Berea, Kentucky, that started as my associate, and she's kind of doing her own thing now. So there's a lot of potential there, And if you're from the community, which is what I would always recommend to somebody, absolutely, go for it. Just the only thing that I would preface that with is make sure that you understand their needs.
Right.
So a lot of the problems that I run into with rural clients or people that at first may seem unsophisticated, but it's really just a cover, trust me.
But
They
she
know more
always-
than you think they know. Don't let their accent fool you, They distrust big city people because big city people come in and they just talk my game and tell them everything that they're gonna do or that they have to do, and they don't like that. They rather just be quiet, and I guess just from instinct, from everything that I've done in my life, I kind of learned how to deal with different personalities, and I try to match their energy. They like to talk, I listen. If they want to listen, I talk. So a lot of rural people like to just have you there sitting quietly and listening to them. They tell you exactly what you need, and anyway, that's just
probably
a good
one of the
tactic.
best pieces of advice you've given so far today. This whole idea of not judging the book by its cover, but on a more refined way. Don't judge people by the way they dress or the way they talk, because in my lifetime, this just happened like a month ago. So I've had this carpenter who helps me with odd jobs and build stuff, and he loves being a carpenter, but he basically works with Crawford Entertainment, helping design cabinets for those people when they go into people's homes to install TV. And I've used him off and on for years. So he says, "How are you doing?" He came out to do something. I said, "I'm doing great." He said, I said, "But I had to stay up late. I've forgotten everything I know about algebra and calculus, and my son's in the 10th grade, and he's struggling. Well, show me what he's doing." So I said, "Yeah, here are my notes. Look at this." And he was fascinated, and he literally could do all of the answers to those homework questions out of his head, standing there. And I said, "How did you get like this?" "Well, I always made straight A's in math, and now my favorite thing when I'm not doing something with my wife is watching math channels on television." I'm like, wow. You cannot define intelligence the way we traditionally do it.
No,
he's
you
one
can't.
of the smartest guys I know.
You can't, and there's a lot of very smart people out there that don't seem that way at first, or purposefully hide that because they want to be underestimated to get an advantage over you, and you run into that. in
Well, they're
business.
very humble
Well,
by nature. They just don't want to show off. Yeah.
So listen to them, and it's a good tactic for any client, I would say, but for those specifically, because the more you let your client talk, the more you can identify things and issues that they didn't even think they needed a lawyer for. And that kind of brings me to my second thing, and I learned this only from Manning Warren, so if he hasn't said it to any of you, I'll say it for him. Go to your client's business, okay? Don't open an office and sit there and take appointments and just be like, I'm king in a castle, people will come to me. I don't even have an office. I work out of my home, and I'm Louisville's also first virtual attorney, because apparently that didn't exist. Nobody had that thought in Kentucky. Since the last 30 years we've had internet, to be a virtual law firm, and I did. And my clients love it. At first, I did get a lot of people that kind of went, "Well, you're a lawyer with no law firm. What are you doing? Like running something out of the trunk of your car, like it's kind of suspect." Especially when you're trying to go after bigger corporations. But very quickly I learned to just tell them, well, do you want to pay for a riverfront office? I would love to take out an office in Main Street, and I'll go ahead and adjust my fees to include the rent in what you're paying me monthly. And they immediately said, nope, thank you very much, we like your fees just like they are. So, you know, that's one of the things that I do, that I found out for the demographic that I want to help. Well, if I can't charge them that, in order for me to remain in business, my overhead has to be as minimum as possible, you know? So that's one of the things to think about.
So as attorneys, like, we do have a lot of overhead with like the resources that we have to like turn to in order to do research. How do you handle that as a sole
Great
practitioner?
question. For 3 years after graduation, you get a 95% discount with LexisNexis.
Oh.
There you see, everybody's like, wow, that's how I can afford LexisNexis. Because, and if you don't call them, they won't tell you, they don't advertise it. So I called them and I said, I actually called them for a job. I said, I just opened my own law firm, do you need a representative in the area so I can make a little bit of money on the side? That's me being uber entrepreneurial. And yes, I do have an Uber driver and Lyft driver account. So yes, I do figure it out. And I said, hey, you know, like, I'd love to have this as a side business. I use my law firm platform to just push LexisNexis on everybody. I'll go sell the crap out of it if you guys will give me some money while I'm getting clients. And they said, well, you know, what do you need the money for? And I said, to pay for LexisNexis, because it's really expensive. It's like $6,000 a month. They're like, when'd you graduate? I said, just, you know, a few months ago, like 10 months ago. They're like, for the next 2 years, you get 95% discount, so like 100 and something a month. And that's what I've been doing. And I got the entire full Monty, even the Lexis Practice Advisor, which, trust me, it's invaluable. It's like my senior partner in the law firm. Because when I get an ask or a question about an agreement or a, you know, a contract that I've never seen before, I go on Practice Advisor and it's on there. You know, and I can tell my client, well, you know, this is what it looks like. We just found out at the same time. So. But the other part of going to your client's office, which is what I learned from Manning, is that when you're there, you see what their business is like. You get to know them on a more personal level. And also, you get to identify other issues that they may have that they didn't know that they needed to talk to you about, you know? It could be safety related. I mean, if you're doing employment, you have to comply with OSHA. So you could go there and you could say, hey, none of your guys are wearing hard hats, and you've got an OSHA sign on the wall that says, wear hard hats. Are you ready for, you know, an OSHA investigation coming down your throat? Then you put hard hats on them, or, you know, figure it out. So, but you would have never known if you were just sitting in your office waiting for the client to come in,
Right.
you know? But by being there, you identify those things, and you're making yourself more valuable to them.
Mm-hmm.
And then you can say, hey, you just asked me to do this employment agreement for you. Would you like me to work on OSHA compliance for you and everything else that you have to do, and make sure that that's integrated into the employee handbook, and that the employees are signing that handbook and that it's binding on them, otherwise you can fire them. And they're like, sure, how much? $100,000. That's when you can prove your value more, you know?
Do you know anything, or have you used, I'm sorry to be on my phone class, but when I had dinner the other night with Bill Strange, I said, well, what forms are you using? What do you look to? He said, well, I use LexisNexis, but over the past 4 or 5 years, now I know when I was doing my 506C research for that Kentucky Law Journal article, I wanted to find, you know, these bad actor questionnaires, so they qualify for 506. And this company called Practical Law, and it appears to have been
From Thomson
purchased
Reuters,
by Westlaw.
Yeah.
Yeah, sorry, Thomson Reuters. And he says, well, that's what I primarily use these days. He says, because they're the most current, they're all lawyer-created documents as opposed to academic-created documents. Yeah. And they're really useful. So it's called, I think that, I'm pretty certain that's where it's Practical Law. And when I was doing a presentation at UK on that paper, I called them up and I said, look, I want to distribute your forms to the people in attendance at this CLE. And they said, normally we'd object, but in this case, no, feel free. And we'll send you the extra copies. I mean, they were super helpful.
Because of that, because
Yeah.
you're just putting a selling pitch for them.
Right, exactly.
they're like, oh yeah, to students, by all
So
means.
maybe they have a discount too for new lawyers.
Yeah, they may. I didn't go with them because Lexis has more securities stuff than Westlaw.
They have forms too?
Yeah,
Okay.
and they had more because, well, you know, a lot of my clients are private equity, and I found that the things I could get from Lexis were just better.
Okay.
than what I was getting from Westlaw.
Okay.
But I did have to get a few other agreements from them before the Lexus didn't even have. So
Okay.
it's you know, the marketplace. You know, everything's different, and the lawyers that they have on one will do it. As I get bigger, I'll probably have both.
I guess
accounts.
going forward, if you ever did grow your business to a point where you wanted to have 3 or 4 lawyers working with you, and you wanted some sort of physical office space, you think you would ever have a library?
No, that is useless.
I think so too.
I have a library on my phone.
Right, yeah.
Yeah, I
And
do.
so do I. All my docs are on my
Yeah.
phone. A lot of the case law I teach is on my phone. But I just wonder because that used to be one of the biggest expenses and one of the biggest disadvantages for small 2 and 3 man law offices. They just couldn't afford the resources. So that meant they had to take hours off every day to head to the law library at the courthouse, which is maintained in most county seats. And that's a lot of time and expense and effort.
Mm-hmm. Yeah, no, there's no need for a law library now, and I actually have more things than just legal stuff on there. I use Dropbox, and you know, don't be afraid to invest in Dropbox. Whatever you need the space. Trust me, especially if you're virtual or semi-virtual. But I actually created a folder of resources, and a lot of my clients were asking me very basic, very simple questions like, how do I do a business plan? And you know, I had an idea from doing business consulting, but then they wanted different formats and they wanted different things. So I went to score.org. Have you heard of it before?
What's it called?
Score.org.
Score.org.
Yeah, so it's an arm of the Small Business Administration. So it's a government website. And they have thousands of documents for free on there.
Yeah.
And I literally downloaded 1,005 of those documents. And I created myself a resources folder on Dropbox, and in that resources folder, I put information for entrepreneurs, information for investors, information for small business owners, for restaurants specifically, for opportunity zones, because I have a bunch of clients that want to invest in them. So I literally learned what they're about and everything, and I made a folder for opportunity zones. Everything that I found for free, I downloaded it, and I send it to my clients. I'll have an initial intake meeting, and the person will say, oh, you know, I really would love to have a business plan, but I don't even know where to start. And I'll say, no problem. And I'll send them a follow-up email saying, hey, here's 2 free business plans from score.org. It's for free. You can go on. There's a government-run website. Never take the credit for anything that isn't yours. People will find you out. In Cuba, we have a saying, it's easier to catch a liar than to catch a one-legged man. So, you know, don't lie to your clients ever. So I always give credit to where it's due. If I find, I literally troll the internet for Deloitte, Accenture, EY reports, anything that is industry specific to my clients or to a potential client that I want to go hunting, because that's another thing when you're in business, you're whale hunting every now and then. And you know, I get the reports, I download them, and I send it to them because they didn't think of reading it before. They didn't even know it existed for free. And I told them, hey, you know, Deloitte just published this thing on fintech, you know, and you guys are a community development financial institution on an opportunity zone investment. So here's some knowledge for you. And I'm their general counsel now. So that's one way that you add value to your clients. It's just identifying knowledge gaps for them. So. Crickets. Any more questions? How am I doing on time? Am I running on?
We're doing fine. We have 10 more minutes if you have 10 more minutes, otherwise.
Absolutely.
Okay.
I have all day. Nobody wants to know what kind of art I did?
I'm gonna ask about kind of your work-life balance and how you balance
It's
work
horrible.
and everything else.
Well, so it's good in the sense that when you're your own boss, you can, you know, take your time off, as you don't have to ask anybody for permission or anything like that. You just have to understand that when you're your own boss and you have no other employees, if you're gone, there's nobody there working for you. So all the 30 tasks that you had to do before you took a week off are there, and they multiply somehow.
While you're gone.
Yeah, while you're gone, they were like bunnies and went at it, and all the documents now have 30 other documents that you have to draft for some reason. And so you have a triple the workload.
That is really true, because when I was with the three-man firm, I go to my partner and said, look, my wife's going to kill me. I've got to take 7, 8 days off.
It's always a wife trying to kill you, isn't it?
Well, I'm sure there are husbands that say the same thing. But the point was, they both looked at me and laughed, you can take off as much time as you want. We're just going to let it pile up while you're gone. Nothing's going to get done.
And that is 100% true. So that, you know, I kind of tried to do, at the beginning, I was just working 27 hours a day. And yeah, you'll find 3 extra hours someday. You know, and it was horrible, especially because I have 2 toddlers, 3 dogs, 2 fish, can't forget the fish.
How old are your children again? I'd forgotten.
2 kids.
How old?
4 and 2.
4 and 2.
Yeah. So, by the way, I had both my kids in law school. So if you think you're having a hard time in law school, try having 2 freaking kids in law school. Don't have children. Yeah, I had to figure out the balance quickly because my wife was going to kill me. And so I started putting in systems. It's funny because when I did the business consulting part, a big part of what I did in strategic planning was building systems so that the business is systems-based as opposed to people-based. And when I opened my law firm, I forgot to just business consult myself. And you'll find that a lot. You'll have great advice, great counsel for somebody, and then you run into the same problem and you have no clue what to do.
So you're systemizing personal time as well, right?
Yes.
Okay.
Literally.
I've got friends who do that, and it
To a
works.
T. I
It
put it on my
doesn't matter.
schedule.
It's like systemizing your yoga, your exercise. You just put a block in there that you know you have to give to others.
Yes, I put it on my schedule, and you know, now I've gotten to the point where at 5 o'clock I'm done, and sometimes I even put my phone on Do Not Disturb, so I only get calls from my favorites, and
Right.
you know, you only put in there like family and relatives. That's a system,
Sure.
you know, and I make time, and now I got to the point where I started blocking time to work because sometimes. So like this month, for example, I had, for some reason, thank God, I had a very good month signing up like 15 new clients, and then I have 15 new clients worth to start doing. But I had the prior clients work, so now this whole week, this is the only thing that I'm doing that is not necessarily work. You know, I block time to work on this agreement. I block myself like 6 hours, and for those 6 hours, I'll turn off my phone, I'll sit down, take an Adderall. I have ADHD, so it's legal for me to take Adderall, don't judge me. I'm supposed to take it, actually. You know, and I just do that agreement and do nothing else, because you'll get distracted. You'll have, I don't even check email. When I block the time to work on something, I don't open, well, I use Safari because I'm on a Mac, but I don't open the web browser, I don't open my email, I don't check anything, because I know that if I start getting distracted, I'll have to call the client 3 months from now and say, hey, sorry, I didn't file your trademark application 3 months ago. So, you know, that's a way to balance work and life. You know, it's you schedule what you have to do. And a lot of it is knowing yourself, you know yourself, know what you're capable of doing, what you can, what you can't do, your limitations. The older I get, the more I get. So, you know, just understand that life happens, and always block a good idea, which is something I started doing, is, so if I have a meeting, I'll block an hour before and an hour after, because if I get any contingency, any problem, any emergency, and I can have that hour or that other hour to work, you know, so the meeting didn't really take away from my work time. So it's just a rule of thumb, and schedule free time for work, not free time for life, like family and all that, but every 2 weeks on a Friday, I have 4 hours at the end of the day where it's just for me to go through the bills and the invoices, and, you know, make sure that my malpractice insurance is paid, and that all the emails are answered that I didn't get to answer during the week. So
we had a rule at our firm where literally from 8, we wouldn't book any appointment unless, of course, exigencies required. But normally from 8 to 9:45 was all 3 of us, and they decided on the rule long before I got. You read.
Mhm.
You read the slip opinions, and you read which are now, of course, all digital, but you read the Wall Street Journal. You gotta set aside an hour and a half a day to read, just to keep up your loose leaf materials in your field. It's amazing how fast you can get through those things, but that 1.5 hour skim makes all the difference. Plus, it's almost like watching a basketball game before you play basketball. I mean, it made a difference for us practicing law.
It is, and I do a lot of that. I actually do it at night when I go to bed because I have insomnia.
Yeah.
There's 2 types of insomnia, and I have both of them, according to the VA doctors. So I didn't know there was just 2 types. I feel like there's 4. But yeah, that's what I do to try to fall asleep. Is I read. Talking
You can
about
read some of my law review articles. That'll help you.
I do read a lot of your law review articles, believe it or not, when I don't want to bug you for a question. But also, I signed up to a lot of publications that my clients. So I want to do entrepreneurship and early stage startups, and I signed up to the Harvard Business Review, which has proved invaluable. It's paid itself like 10 times already. Because I can get an article, I can send it to a client. It has ebooks, it has pamphlets. They have so much information in there that I've even learned a lot of things about business and business consulting just from my subscription. I send it to my clients all the time, which they love it. So, find publications in your field that are not law related, that are what would your client be reading, If you're a family attorney, sign up for mom blogs and, family resolution therapy or whatever it is. Just find things out there that, number 1, your client might be reading. Number 2, they might be interested in, so you could send it their way if they haven't read it.
Simply, you send the email, you may have seen this, but I thought you'd find this interesting, and attach that article. I did that all the time practicing law. And they love it, even if they've already gotten the article. They love the attention, sort of like getting a package.
Thank you for thinking of me.
Yeah.
Thank you for thinking of me, and that's actually the best email I get. It's better than where the hell's my agreement? I get those a lot too. But I do that a lot. I actually schedule time to do that, and clients love it. Just you're thinking of them. You have their issues, their needs in your mind. And a lot of things you'll find trends and insights in their industry or their life group or whatever it is that your client's involved in, and you'll send it their way. And it could be, if you're a family attorney, you could just see new mindfulness class for transitioning families offered at the YMCA, and you could send your client that pamphlet and say, hey, I know you and the 4 kids are having a hard time.
I've heard this is good. Yeah.
Adjusting. I heard that this is really good. Maybe you guys should try it. And they'll be forever grateful that you're thinking of them as more than just, pay the bills type of thing. So.
When you were doing business consulting, were you running into blocks of, I could do this had I had my law degree at that time, and then wishing you had the law degree and just waiting in anticipation, or was it more like self-contained?
So I had one client that kept wanting me to be their lawyer. And I keep telling them, if I'm your lawyer now, I'll never be able to be anybody's lawyer, because that's, what is it, legal practice of the law or unauthorized practice of the law. So I said, what I can do is, you get an attorney, and I'll go and I'll talk to the attorney with you, and me and the attorney could spitball. And if the attorney wants me to do some of the legal research, so you're not paying their hourly fee, I'll do it, and I'll send it to him, and so kind of like be the lawyer's intern, but don't practice law, and that was a big knife's edge that I was traveling, because a lot of the business consulting clients would ask me for advice on this or that, but the rule of thumb was, if I Googled it and they could find it within like 2 searches on Google, I would just tell them, and maybe I'll even send them an article and be like, hey, here's this on what to do for your taxes or whatnot, because I can't really give you tax advice. So things like that. And I wanted to get my law license, so I was protecting my chance to have my law license. Right. I didn't want somebody, and I was more scared than anything of a lawyer in town that may have been representing a client or may have been going after a client's business coming and saying, oh wait, that business consultant told you this and that, that's unauthorized practice of the law, and try to take the competition out. before it even competed. So
Well, I told this class not long ago that one of the little niche practices I developed, I really didn't want this niche practice, but before long I was getting a lot of calls from law firms, was law firm dissolution. You know, you got partners that have come to hate each other, and they're stealing files in the middle of the night, and they need representation too, so I got to be a law partnership divorce attorney for a while. But another little area that became a niche, just listening to you talk, was when transactions had been broken by other lawyers. In other words, everything's screwed up. And it's tricky because you don't want to go in and step on another lawyer's toes, but in every area of the law, there are lawyers that have messed it all up. And people will call you, usually they fired the lawyer, but they said it's just junk. I mean, it's like they've junked up the whole transaction. They've junked up the whole lawsuit. And I seem to get a lot of those calls where you would literally come in. It felt good because you're like and I've got a lot of nerve, so you're the guy on the big horse coming in to save the day. But it's amazing how many lawyers. None of you ever will, but it's amazing how many lawyers will.
please don't.
Will have gotten. Usually, it occurred because they got too busy and they weren't paying attention, or they just got into a field where they had zero knowledge.
Well,
it happens in every field.
I'll tell you exactly something I ran into. That client I was talking to when I was up there waiting for you, they're an investor. They want to invest in a local tech company. They call me from Spain, Tarifa, Spain. He can see their horn. He can see Africa from his driveway. When we do a video shot, it's a pretty cool guy. But you know, he contacted me through a mutual friend, and he sent me an agreement that the local tech company sent him. And I said, look, I read the whole agreement with a fine-tooth comb, and I said, it doesn't matter if I put it under a microscope, this is shit. You know, it looks like it was downloaded off the internet. Formatting's all messed up and everything. And, you know, I told him if they have a lawyer, the lawyer hasn't seen this. If the lawyer saw this, he should be shot. But more likely than not, this looks like a startup company that downloaded an agreement of some website and asked the lawyer, hey, would this be all right to raise money? And the lawyer said, yeah, sure, Bob, go raise money with that, unless you want to pay me, you know, $1,000 for me to actually read the agreement for you. And they said, no, we don't want to pay you because we aren't being funded, and there's one investor in Spain that is going to be your first funder, and let's send him this. And he contacted me, and I said, I sent him what I would use for an agreement, and then he got scared because he said, whoa, they're not that sophisticated. You know, like from the agreement they sent to the one you sent, there's a huge difference. But, you know, I may have got every bell and whistle in the drag-alongs, tag-alongs, put rights, call-out, you know, everything.
You remembered.
I have to. I literally practice this every day. So, you know, I have everything in there for him, and so my challenge was how do I unsophisticate my thing but still protect my client?
You mean just how to simplify it?
How to simplify
without
it. So
losing protection.
I literally went into.
You usually can.
Yeah, and I went into their agreement and I just changed a few of the provisions, and I made sure that there was some protection in there for minority investors. And I told my client, I said, look, this isn't perfect. This isn't, you know, you're the one spending your money in them. So at the end of the day, it's your money. This isn't perfect. This isn't 100% what I would want you to have to protect your investment, but it will protect your investment, you know, if even like 50% of what I would ideally, you know, put in there. But I just took their agreement, cleaned it up, format and everything, and just wrote in red the small little things and put in some definitions I didn't have in there. And yeah, just cleaned it up for them. So and you run into that. If they do have a lawyer, because he says, oh, they say that their counsel was the one that did it. And I said, well, then I hope I don't find out who that is, because I'm going to give him a call and say, what the hell are you doing? You know, it's probably some general practitioner that it's now doing securities law all of a sudden. And I told my client too, I said, look, after you give him the money, you got 15 days to file a Regulation D, because it's a private, it's
15 days after the first sale.
Yeah, it's a private offering and it's exempt from registration, but you still have to, it's not 100% exempt from registration. You got to do the Form D registration, I guess. And, you know, I told him that, and he's like, oh, they didn't even mention that. And I said, I sent my client a copy of Form D, and I said, this will be in public record, you know? So you have to be comfortable with that. So that's one of the things that their attorney didn't really advise their client to divulge or disclose to the potential investors. So that's a way for you to identify, in my case, my value to my client. You know, if I was representing the company, I would probably be trying to make it so that the minority investor has less protections and less provisions, so that they can do whatever they want with their equity and with their firm without having, you know, a bunch of activist minority shareholders. But if I'm representing the minority shareholder, I want them to be as activist as possible. So given the biggest fighting chance. So how many hats you're wearing, you have to understand that. So.
Other questions, class? Well, Carlos, this has been great. Thank you so much for
I used to be an oil painter. Nobody asked me that. I'm an oil painter.
You'll return to that, right, one day?
I know. I actually got my easel out of storage, and I'm hoping that I can paint sometime in March.
Just paint at home.
Yeah, I know. But,
Well, will you sit with us and listen to this presentation, or you need to get
absolutely.
out?
No, I'll listen to
Okay.
it. Actually, let me I think I have enough cards.
So that was another question. Do you mind if these students, after they graduate, and if they're out there with issues of solo practice, do you mind if they get in touch with you as a contact?
Not at all. As a matter of fact, as the local bar association, you're supposed to get in touch with me and pay your memberships.
How much is the membership for new members?
It's
$50 a year?
dirt cheap. Yeah, it's like $50 a year, and it's one more network that you get access to. And if you do the
And other lawyers are a great source of clientele. They were my best source practicing law.
and not for me,
No?
no, not for me. But what they are a great source of is a place to dump the clients you don't want. So I'm not just saying bad clients, but when I get a divorce client. Yeah, conflicts of interest. So I've already been conflicted out of 2 or 3 clients. That took no time at all, and so I can call another lawyer and say, hey, look, I'm conflicted out of this transaction. Could you represent the other person? So. Who? Oh. Damn, just enough. And the last one.
Thank you, sir.
You don't need one, man.
I've already got 2.
Yeah, I know. Actually, you know what's funny? I had a client that does framing, art framing,
Yeah?
and he saw it and he's like, oh, it's so pretty. And I was joking. I said, maybe you should frame it. And I said, give me 2 and I will. And he made me the most beautiful frame of my business card back and forth and sent it to me.
That's a cool thing. So we
Yeah.
did a firm announcement when I was added to the firm. And it appeared in one of the local newspapers, but my partners framed it for me. It's still on the law firm of Richie Reddick. Announces it's changing the name of the firm to Richie Reddick and Warren. It's super cool.
Yeah.
You had a business card to buy.
Oh, I frame all those things. I still have the first $500 check given to me framed.
A photo.
Yeah, the first client. No, I framed the actual check because I did an electronic deposit, so I framed the actual check.
Okay, good.
My first client payment, I framed it and I said,
You want to pass them back?
No, that's just for you to have. Oh, yeah, I guess you could have.
oh, look at that. Great segue.
So before we get started, I'm just going to pass around a private placement memo. I know that, we talk about it a lot in this class or in securities. Sometimes, you don't really see you don't see what it looks like, so you might be curious. So you all already know. I'll go with you. You can just pass it around. So, my name is Nina Ziffel, and this is Tia Stewart, and we are co-presenting private offerings and registration exemptions. And contrary to what Professor Warren had said earlier today, that I guess in order to discuss Rule 506C, we sort of have to go through Section 4A2 and the other Reg D exemptions to sort of demonstrate how it is different and why the SEC sort of created 506C. So what exactly is a private placement memo? And it is a disclosure document that's given to investors about the investment that they are being offered or that the issuer is disclosing to them. So it tells them what the price of the security is, how much the investment is worth, the structure of the deal, so whether it's equity or debt, and probably other information such as the management team, if they've been successful in other ventures, any tax implications, and any regulatory disclosures. So the reason why there are private placements is because the SEC, the Securities Act of 1933, mandates that all offerings are registered. The act does not define what a private or public offering is. So a lot of issuers, new companies, are faced with this problem that they have to register these securities, but that can be costly and can also sort of, for privacy reasons, they may not want to disclose that information by registering a public offering. And if the company does not register, there are implications such as criminal implications and SEC violations, as well as a private right of recovery under Section 12A1, that's the rescission rights. And Section 12A1 grants an investor the right to rescind the transaction in an action brought against the issuer for violation of Section 5. So if the company fails to register with the SEC, all investors can rescind the money that they gave, so the investment that they gave to the company, and that essentially just, retreats all of the infusion of capital that company got. And that's if they fail to register with Section 5 or if they perfect an exemption of Section 5.
And I think they have to pay interest. Didn't you tell me that, rescission?
They
You
do,
get your money back
they do
plus
under
interest?
the counterpart in the Kentucky
The
Securities
Kentucky,
Act.
it was state law, okay. Sorry.
And so Section 12A essentially imposes strict liability on the issuer to comply with the Securities Act of 1933 and the registration mandates, or perfect an exemption from those registration requirements. So issuers need to make sure that they are complying with, the SEC regulations. So the SEC created exemptions from registration such as Section 4A2 or safe harbors, which is Reg D. And an issuer may choose to register a private offering, but due to cost and privacy reasons, most usually choose to perfect an exemption from registration. And so the available exemptions are Rule 504, Rule 505, which has been repealed, and Rule 506. And Rule 506 is the popular choice among practitioners and businesses. So the first one is Section 4A2, and that is in the Securities Act of 1933, and that exempts registration of transactions by an issuer not involving any public offering. So, like, what exactly does that mean? And to comply with Section 4A2, all offerees must have access to information necessary to make informed investment decisions, such as financial statements, operating agreements, bylaws, etc. And the Supreme Court's seminal case, Ralston-Purina, explains how 4A2 protects investors and why the registration requirements are in place. But under 4A2, there's no general solicitation, and all offerees must be financially sophisticated or be advised by someone who has the requisite acumen to explain the risks of the transaction, the nature of the transaction. So in Ralston-Purina, the Supreme Court ruled that the design of the Securities Act of 1933 was to protect investors from promoting full disclosure of information thought necessary to make informed decisions about the investment. Offerees have access to the kind of information that registration would disclose. That's important that offerees have that access to the information. And in Ralston-Purina, the issue was employees taking stock in the company, and the court held that all employees were not these key employees, which the company was trying to label them as, and therefore they didn't have the type of information, the type of access to information such as the CEO or the CFO or maybe the board might have for the company. And again, the purpose of 4A2 and like the underlying theme of Ralston-Purina was to protect investors. And in that case, the Supreme Court identified that a private offering is an offering to those who are shown to be able to fend for themselves. Thus, they do not need the protections of the Securities Act of 1933, and registration under that act. And so, those individuals, a part of a private offering, that don't need the protection from public registration was to sort of define who those individuals were and sort of lay the groundwork for Reg D and other exemptions from registration. So Rule 504 is one of the exemptions for Section 5. It was amended in 2017. These are some of the conditions that issuers need to satisfy in order to perfect an exemption under this rule, such as there's $5 million cap on all investments over a 12-month period. There's no limit of purchasers. The securities are freely transferable, but they must comply with state law requirements. There's no specific disclosure requirement, meaning that the issuer doesn't have to disclose information to these investors, whereas if it was a non-accredited investor, as we'll see in other rules, the issuer has to disclose certain information. The manner of offering under Rule 504 allows general solicitation, but to accredited investors only, and of course, the issuer is still subject to state laws. They must comply with blue sky laws, and they're subject to anti-fraud provisions. Rule 505, which has been repealed, was very similar to Rule 504. It has a limited accredited investors, however, no more than 35 non-accredited investors or purchasers. There was a resale limitation, so there would be legends on the actual securities that said that you cannot transfer these securities to someone else. They would have to have the legend removed before that resale occurred. And there was a mandatory disclosure requirement to non-accredited investors, such as financial statements. Under this particular rule, the issuer cannot engage in general solicitation. And again, this, the issuer is subject to state laws and anti-fraud provisions. So from those, the SEC also had, also made a regulation, Rule 506, which was fell under Regulation D. And before the Jobs Act, that was the traditional 506, there was no general solicitation, and we'll discuss that when we get to 506C, what general solicitation is, or general advertising. The Act ended the SEC's prohibition, the absolute prohibition on all general solicitation, and it sort of bifurcated Rule 506C into two parts. Also, under the traditional Rule 506, issuers were allowed, so under 506C, which came from the Jobs Act, issuers could use general solicitation and general advertising to solicit purchasers, but they had to fulfill certain conditions when they actually made the transactions. And there was no restriction on who an issuer can solicit, but an issuer faces restrictions on who is permitted to purchase the securities, and that's the main distinction between Rule 506B and 506C. So general solicitation is kind of what it sounds like, general advertising. Rule 502C, like the definition rule of Regulation D, provides two broad categories of general solicitation, and that is an advertisement, articles, notice, any sort of public communication in a newspaper, magazine, or other media, so such as social media, broadcasts over television or radio, or any seminar or meeting, like face-to-face type communication. And that included the in-person communication or the one-on-one communication included telephone calls, direct mail, websites that weren't protected by passwords, and in-person communication. General solicitation, however, is not it does not occur when an issuer or investor has a pre-existing substantive business relationship. So in order to save Rule 506B, issuers will establish, or their agents will establish, a pre-existing substantive business relationship with prospective investors. So then they can solicit these offers, or they can solicit these investors for a private offer. So 506B, there's no cap on aggregate sales. There's unlimited accredited investors, and we'll explain what accredited investors are when we discuss Rule 506C. And Rule 506B allows an issuer to offer and for purchasers that are 35 non-accredited, financially sophisticated investors. So Rule 506B allows an issuer to reach out to individuals that they have a pre-existing substantive or business relationship with that are non-accredited, but those individuals, those investors, must be financially sophisticated. And financially sophisticated means those investors have sufficient knowledge and experience in financial and business matters to evaluate the investment. Rule 506B also requires self-certification, which is like a lesser burden than an independent verification, as we'll see in Rule 506C. Self-certification, the issuer can accept a statement from the investor saying that they are accredited and they meet like the minimum requirements for an accreditation status. And under Rule 506C, if an issuer perfects under this rule, under this exemption, there are resale limitations, and again, the securities may not be resold unless there is registration, so like a private offering, or the new investor is able to perfect another exemption. There is a mandatory information requirement, but only for non-accredited investors. And again, if this information is disclosed, if any information is disclosed to non-accredited investors, then that information must also be disclosed to the accredited investors. The manner of offering, it excludes general solicitation. And again, there must be a pre-existing substantive relationship. Any securities that are perfected or that are exempt under Rule 506B are covered securities, which means that the National Securities Markets Improvement Act preempts all state law regarding securities in the state. So any securities perfected under this exemption do not have to register with the state or comply with state law, but they are still subject to anti-fraud provisions. So what exactly is a pre-existing substantive relationship? This is a relationship that enables the issuer or its agents to have a reasonable basis to believe that the other party is an accredited investor. Basically, that you've done business together. This relationship can also be established through a questionnaire. So some issuers will create a password-protected website where they have a questionnaire and they require the prospective investor to fill it out. And once they fill that out, they sort of are then put in sort of like a holding period. And as so long as, X amount of months pass, then the issuer and the prospective investor have created this pre-existing substantive relationship. And the purpose of that is to allow issuers to evaluate whether the prospective investor has financial sophistication, understands the nature and risks of the investment, and like whether they're suitable for that investment.
Okay, so Rule 506C, there is no maximum offering. You can have any amount as you're offering, as opposed to the other ones which had caps. The number other than 506B. The number of purchasers is unlimited accredited, which we'll talk about here in just a second, what exactly accredited investors are. There's a resale limitation like B, where securities may not be resold without registration or an exemption. There's no required delivery of mandatory information like the other disclosure requirements. Reg D irrebuttably presumes that these investors can fend for themselves. Because they've proved themselves to be sophisticated, they won't be taken advantage of, I guess is the rationale behind it. And the manner of offering can be general solicitation, and general advertising is permitted. And then the independent verification of accreditation, the issuer must take reasonable steps to verify, and the burden's on the issuer to establish that it has a perfected exemption from registration. But the burden is still heavy, and it's prudent to maintain adequate records so that you can go back and prove that these people were accredited, and if you were to get looked at or investigated by the SEC. And then third-party verification could alleviate this burden, but that's discussion. There's subject to anti-fraud, which means any information must be true and may not omit material facts necessary to prevent the statements from being misleading. And then accredited investors are individuals, institutional investors, directors, executive officers, and general partners. It can be private business development companies, tax-exempt corporations, anything like that. For individual investors, the income must exceed $200,000 combined with your spouse over 2 years, and you must reasonably expect the same in the next, or the current or next year. And then the other option, if you don't satisfy the $200,000 a year, you can satisfy the net worth over $1 million. So together with you and your spouse, excluding the value of the investor's primary residence. If you have a big house that's worth $1 million. You may not. And then institutional investors can be any institutional investor or ERISA plan with total assets in excess of $5 million. So it's kind of like the individual investor, only it's a way higher.
It can really be any corporation with assets.
Right.
Excess of
We have
$5
another
million.
slide that.
Gotcha.
And then directors, executive officers, and general partners can also be accredited investors. Certain insiders of the issuer are accredited. This includes, like the title says, directors, executive officers, and general partners of limited partnerships. And executive officers, if you've not taken business, because I think you have to if you're in here, it's like CEO, CTO, CFO, CLO, all those. Okay, corporations with assets in excess of $5 million can also be accredited investors. Tax-exempt tax-exempt organizations, originally open to college or university endowment funds with assets in excess of $25 million. They expanded to include all organizations that are exempt under 501c3. Lowered assets level to $5 million later on. And then the Regulatory Vortex is a paper written by Professor Warren, and it discusses how complex the statutory and regulatory exemptions and how, because they're complex, they've created what he calls a regulatory vortex that drives all private placement users to use Reg D 506B as opposed to 506C. And he relies on 5 reluctance factors that describe this push for investors and practitioners to use 506B as opposed to 506C. And it's because 506B is practicable, it's reliable, they've used it for some 34 years now, and it's one of those if it's not broke, don't fix it kind of things. And then second, issuers are reluctant to offer to accredited strangers as opposed to people with whom they have a pre-existing business relationship or relationship in general, like we discussed earlier. They've done business together before. They're more comfortable with doing business with people they've done business before rather than going and finding strangers just to satisfy the statutory exemption. And then 3, they like confidentiality and advertising offerings and other public displays. It threatens to expose confidential information just to the public in general, which could mean competitors get information they don't really want them to have in their hand, or potential competitors, someone who was thinking about expanding and sees that your public info and thinks I could do that too. And then 4, confidentiality from the state and federal regulators too, because there is all the disclosure documents that you have to have. And then there's reluctance finally because of 506C's mandate that issuers engage in independent verification process in order to determine the status of accredited investors.
And to add, if an issuer exempts under 506C because they engage in general solicitation, then they would be sort of kicked out from the safe harbor of 506B or 4A2 because those specifically prohibit general solicitation. And so to conclude our presentation, this was some things to consider. So if one of your clients are approaching you asking how they can raise capital or equity for their business and they need to do a private offering, these are some questions that would be good to sort of plant in their ear, and also for you to consider as well as their advisor or their attorney, such as, so what do the financial statements, if provided, do they tell you about the business? Are the claims and exceptions reasonable? How reasonable is the issuer's reliance on a particular technology, customer, product, natural resources, such as, like, do they have any competitors? And what is the experience and background of the management? And again, hopefully that this may be in the private placement memo. If not, these are questions that would be useful to ask if you're representing your client who is an investor, or to include in the private placement memo if you are doing the private offering. And lastly, is the investor comfortable holding the investment indefinitely? Because there's a good chance that if the business doesn't go public, you know, as we'll learn later in this semester, what are the ways that an investor can get their money back, sort of ways to get out of this investment. Do you have any questions for us?
So what other documents do you need in connection with this transaction? I want to help you set up your practice.
Would be financial statements.
So you're going to have to do, as the lawyers, you're going to do some due diligence, right? Because you're preparing, perhaps you're preparing a disclosure document. And I'm assuming you'd use 506B. Do you recommend one or the other as part of your talk?
So when the research that I was coming across, it honestly depends on what your client is looking for. So as you had noted in your paper, that a lot of the times that professionals prefer 506B is because it's a sort of a red flag if they can't drum up business or they can't drum up investment before they go to advertising or general solicitation. So perhaps there might be a reason why that investor, why that issuer needs to go to general solicitation. Another concern that I think needs to be considered is if there is such a large offering, sometimes under Rule 506B that can look a lot like general solicitation. So then perhaps it would be better to do that offering under Rule 506C, and to alleviate some of the concerns with disclosure about financial wealth, the investor can independently verify their accreditation status through a CPA firm or through a third party that the issuer has agreed to or has recommended, or someone that will independently verify the accreditation status but also keep it confidential. So
without the issuer ever seeing that data.
Well, I mean, no, the
I
issuer.
don't know. It's not a trick question. I don't know yet.
That is one of the approved ways per
Right.
the SEC is to do a third-party neutral.
Right,
Yes.
okay.
You can also have your legal counsel offer a legal opinion certifying you that you are an accredited investor because of the attorney-client privilege. That's a service you can lend.
Ooh.
There you go.
Awesome, thank you.
You mentioned like really early that there were criminal penalties for failing to register. I guess two parts is who would be, I guess, criminally liable for that, and then what kind of penalties are those? Just financial, or are they actual jail time, or?
Well, so criminally liable would be the issuer, because it's the issuer's ultimate burden to prove either they comply with Section 5 or that they perfected an exemption. And if for some reason one of the investors somehow messes it up through lying about their self-certification, their accreditation status, or if the independent verification was false for some reason, the ultimate sword falls on the issuer, and it ruins the placement. So again, there's rescission rights as we have discussed, but there's also criminal penalties, whether that's through money or possibly jail time. I think that would just depend on the preference of the SEC and how much of a message that they're willing to send, because that seems to be their MO. But yeah, hopefully that answers your question.
Thank you.
Any other questions?
Yeah, there's, just to add on to her answer, there is definitely jail time. So the SEC does not have, as she suggests, does not have criminal enforcement jurisdiction, but it simply packages things up all the time and gives them to the Department of Justice to get the jail time. But of course, there's also monetary penalties, civil and criminal monetary penalties. So it's pretty big. Question is, are they going to go after our clients? Probably not. It's relatively small offerings in Kentucky. They're probably not going to pay a lot of attention. But so the bigger risk, I always tell clients, is that you're going to get the building built, the factory built, the distillery built, and along comes some guy who suddenly decides he needs the money for his kid or his mother or whoever, and he wants his money back. And he goes to a lawyer and says, "How do I get my money back?" And the first thing the lawyer's going to say is, "Well, you sort of can't. You've invested equity in a business is, you know, equity doesn't give you a contract claim. There's no debt claim. So you gotta wait until the company liquidates, and you'll get your share, or it has some exit event. But the really sharp security lawyer, you know, who's probably had a securities course, gonna say, well, you know, I bet the guy didn't really perfect his exemptions from registration, and then you have a full-blown attack.
They didn't file Form D.
Well, the filing form, the failure to file Form D will not really kill it, but it helps, filing it helps keep the state guys from coming at you, because they assume if you file the Form D, it's 506, and they have no registration exemption jurisdiction. They've got fraud jurisdiction, no registration. So, but the investor coming to a lawyer like Carlos, who says, oh, well, so where'd you hear about the offering? Well, there was this meeting at our church, you know, one Sunday night, and everybody was there, was told if you're over 60, you need some retirement income, this is a great place to put it. One of our deacons is running it. This is called affinity fraud, and it happens all the time. And you can't really blame the parishioners, the churchgoers, because they don't know the deacon is corrupt. So, and even if the deacon's not corrupt, the deacon doesn't have good legal advice. So suddenly everybody in the church, they all know each other, but that's not that's not the pre-existing substantive relationship we're talking about with the deacon, probably. So the deacon proceeds to get everybody to sign up. Then, you know, lo and behold, one of the women or men who invested is in your office 6 months down the road and wants her money back. It'd be pretty easy, because Carlos would then pick up the phone, would not go to the expense of filing a lawsuit, picks up the phone, calls the lawyer for the deacon, says, we got a real problem here. And they may negotiate a satisfactory resolution. The deacon might say, you know what, once his lawyer says he's violated the registration requirements, it's a potential jail time, and certainly 12A1 rescission, and Kentucky Securities Act rescission, which gets you interest of 6% plus attorney fees. And it's not like a guessing game. And this is one of those few areas where it's pretty
attention to detail.
Right, it's pretty determinate. It's not ambiguous. It's pretty determinate in terms of resolving it. So what are you going to do? This is a great question for you. What are you going to do if you're the lawyer who gets called by the lawyer who messed it up, and you get the call, Anita, and the lawyer says, look, I messed it up. I'm not sure this guy who's representing this investor is right or not. Would you help me with this? And the client's agreed to bring you into it or bring you into it. You get on the phone, you're trying to find a solution, and the solution might well be, you can argue, but he's going to win. Under the facts I described, he's probably going to win. So you're going to argue, you're going to say, well, and what's your big fear? What's your big fear if you're Anita Zipp in this situation? Your big fear is that his client is going to go talk to the other people who invested, or if he files a lawsuit, they're all going to find out, and they're all technically entitled to their money back, not just the first complainer, all of them, which will destroy the whole deal. So what you want to do is quietly negotiate a settlement with his client. And I had one time where I had to do this, where I literally said the guy didn't have the $100 grand, but you know what? He can come up with 50 now. He can get that from some relatives. We'll give you 50 now, we'll pay you the additional money over a year and a half. And yeah.
Why couldn't I just call his bluff? Because it's criminal charges. He's not going to get, his client's going to be screwed. Like, you know what I'm saying? Like, if I get thrown in jail, he doesn't win. So why don't you just call his bluff?
Well, that's why he's not going to call the U.S. attorney. I mean, that'd be really dumb, right? Him call the U.S. attorney.
Yeah, but do you want to be in jail and lose your whole corporation? You just went through 10 years,
probably
worth of funding,
and he doesn't get his money back. His
Right.
client doesn't get the money back if he comes in and threatens jail.
Right.
Also, threatening jail is borderline extortion.
Mm-hmm.
You know, I want my money back, or I'm calling the Department of Justice.
Yeah.
You know, so the trick is to make sure you guys perceive that all investors may get their money back, or you may go to jail, versus simply paying them his 50 grand. You know, and so it's one of those things where it involves as much thought, more thought than law. And that's what I love about practicing law. Very often, if you've got the basic tools as a lawyer, you don't have to use them. I mean, they sort of are there, but the main thing is considering outcomes, like you're playing a game of checkers. You know, it's just thinking through how they will react to the things you're going to present, and do that before you get on the phone with them. You know, you sort of know your strategy.
just to throw an example out there, it didn't have anything to do with securities. It was actually a copyright issue, and I had a client that was a minority, and they were getting battered by like this big corporation. The corporation actually filed a lawsuit against him as an artist and said, "We own the thing that you did for us. You know, you didn't really own it. You were like a hired hand." I checked the agreement. It was just a bunch of email exchanges. So there was no actual agreement or anything like that. So my artist still retained the right. He was smart enough when he realized that the corporation was making money off his design to register the copyright, which gives you, I don't know if you know intellectual property, but it gives you statutory damages. And it can be up to like, I think it's like $15,000 or $25,000 per infringement. So even if it's just, you know, a tiny little drawing, if they used it 10,000 times, that's $25,000 times 10,000 times. And this corporation actually filed a declaratory lawsuit just to have a judge say, hey, it wasn't your design, it was theirs. You know, kick rocks, kid. So I was with this law firm that had like 8 lawyers, 2 of the general partners, and like 6 associates, trying to breathe down my neck. I only have been practicing for like a month, but all I had to do was simple math. And I said, look, you registered so and so date, you started selling it so and so date, you sold like 600,000 of the damn things. The lowest case out there would be like $15 per infringement if it's a tiny little thing to kind of not bankrupt somebody. You're looking at $150 million. My client, like I literally talked to my client, I said, well, we'll make a material difference for you and your family, because this is gonna be long and protracted, and he didn't have the money to pay me anyway, so he said, dude, if they give me $50,000, shut the hell up and walk away. I'm just really pissed off that they, you know, rebuffed me like they did. So
He got the 50 grand?
yeah, he got his 50 grand.
That's pretty good.
He got his 50 grand. I said, look, you can pay 50 grand, or you can pay 250 million if we do go to trial, and spend all the legal fees and all the crap that are gonna go along the way.
That big company's gonna have
So
50
they wrote that check very quickly.
And I'm guessing that was like a contingent fee and not a flat rate that you were talking about earlier.
Actually, it was a flat rate
It
because the guy
was.
didn't have that much money. Yeah,
It was-
yeah, and I was trying to help him.
Right.
So so you don't always want to, you know, fleece your clients as they will. I only charge him $3,000, full disclosure.
He'll be
For the whole
a
thing.
client for life.
Exactly, you know, and I knew he couldn't pay. He couldn't even pay me the $3,000.
Yeah.
And it was a big chance because I wasn't actually willing to go through, because it was filed in federal court, I wasn't willing to go through all that. I had to go get sworn in federal court. And I told him, look, if they call the bluff, you're gonna have to hire somebody, you're gonna have to actually pay.
Mm-hmm.
And, but hey, he got his money, so.
Are there any like punitive damages as well because it was so egregious?
Actually, see, there's it's a certain statutory amount before notice. Once you give the notice in the form of a cease and desist letter, I registered this copyright, please cease and desist from using it. If you continue infringing from that point on, which they did, it's now willful infringement, so statutory damage goes up considerably. So yeah.
And also, as you had told us a while ago, that like if your investors are happy, they're not going to come and ask for rescission rights. They're not going to rescind their investment. So.
And how do you keep
Keep
them
them-
happy? You keep them informed. Most of the lawsuits I've seen is where the company just, at some point, the investor calls after 3 or 4 years and can't get anybody on the phone, and then they get mad and they go to a lawyer. And so part of our job is to educate the client to send out periodic information about the company. I mean, I had one client who did private place pretty often. He'd send Christmas cards to all the investors along with the annual report. And sometimes he'd send cookies. You know, just things to keep everybody happy going forward. Makes a lot of sense.
Because most of the time they enter into that investment like knowing the chances of liquidity are kind
Or
of
small.
small. I mean, you hope for that, but they're probably doing it because they do have some sort of attachment, non-monetary attachment to that
Right.
corporation or that investment.
And building that, I think, is a good idea.
Mm-hmm.
Well, just look at what, you know, with the information you said, now go to any public company's website, and you're gonna find a little tab, whether at the bottom, like along the contact us fine print, or at the top if they're new and they don't know how to hide it yet, that you're gonna see something that says investor materials.
Mm-hmm.
And you click on it, and it'll show you everything. that they send, that's a way for them to say, hey, it's freely available on our website, you could have come and checked it any moment in time.
Have you noticed over the last 5 years or so that even you go to corporate websites, there's no phone number anymore?
Yes.
There's nobody to call, not even the press office.
Even if there was, it's a chatbot. You can hire somebody that's not even a part of the company to answer the calls and field calls for you.
Yeah.
So,
Wow. Well, great job, guys. Really enjoyed it. This was fun session. All right, next time we have Chuck Schneider, the owner of Heine Brothers and former general counsel for Papa John's. And we have Austin Bates talking about angel investments.
Papa's brother. That's cool.
Huh?
That's cool. Papa's brother.